After expenses, gas, carware, self-employment tax, the average gig worker's effective hourly rate is $5.12. Not $15, not $11, $5.12. That number came from Human Rights Watch in 2025. It wasn't a fringe study. It was a survey of real workers, real receipts, real math. Some workers surveyed reported earning nothing. After every expense was accounted for, zero. And here's the part that should stop you cold. It's completely legal. In this video, you're going to understand exactly how that happened. Not because the economy changed, not because technology disrupted work, but because of a specific legal classification. One most workers never consciously agreed to, one most people don't even know exists, that quietly removed every protection the word job used to guarantee. Minimum wage, overtime, unemployment insurance, workers' compensation, the employer's share of your Social Security. All of it, gone, with one signature on one form. By the end of this, you'll know when that loophole was written, who built a trillion-dollar empire inside it, and what it costs you, whether you've ever opened a gig app or not. This story doesn't start with Uber, it starts with a tax form. In 1917, the IRS created the 1099. It was designed for one kind of person, the self-employed tradesperson, the independent plumber who owned his tools, set his own prices, took on multiple clients, and ran his business on his own terms. Not an employee, a true contractor. That distinction existed because it made sense. Then in 1938, Congress passed the Fair Labor Standards Act, the law that gave American workers a federal minimum wage and the 40-hour workweek. Those protections applied to employees. Independent contractors were excluded, because at the time that category was narrow. It described people who genuinely ran their own operations. It was not designed as an escape hatch. But a trapdoor had just been written into the foundation of American labor law. If you could call someone a contractor instead of an employee, you didn't have to pay them minimum wage. You didn't owe them overtime. You didn't contribute to their unemployment insurance. The savings were significant, and for decades, some industries quietly started using it. Then, in 1978, Congress made that escape route permanent. Buried inside the Revenue Act, lawmakers added Section 530, a provision that gave companies a legal safe harbor. If a business had a reasonable basis for treating workers as independent contractors, a prior IRS ruling, an industry custom, common industry practice, the IRS was prohibited from reclassifying those workers as employees, and Congress explicitly blocked the IRS from issuing any new guidance on how to draw that line. That provision has never been updated. It is still in effect today. Fast forward to 2009. Garrett Camp and Travis Kalanick launch a black car service in San Francisco called Uber Cab. By 2013, Uber has expanded to regular drivers, everyday cars, surge pricing, and 5 continents. The company is growing at a pace the American economy had rarely seen. And early on, Uber made a decision that would define not just their company, but an entire sector of the American workforce. Every driver would be classified as an independent contractor. Not because drivers requested flexibility, not because it was structurally better for them, but because the contractor model eliminates the single largest ongoing cost in any labor-intensive business, the full legal weight of what an employer owes every worker they hire. No minimum wage floor, no overtime liability, no unemployment fund contributions, no workers' comp premiums, no employer Social Security match. Uber didn't invent the loophole. It had been sitting in the tax code since 1917 and locked in place since 1978. Uber just built a trillion-dollar platform inside it. And every platform that came after copied the model exactly. Here's how it works in practice. When you sign up to drive for Uber, deliver for DoorDash, or shop for Instacart, you don't sign an employment contract. You sign a service agreement, the same form a freelance architect might sign before designing one building for one client. That single document makes you, legally, a business owner, a sole proprietor, and it means the platform you work for owes you nothing beyond the per-trip rate they decide to pay, which they can change at any time without notice. Think about what that actually means in dollars. If you work at a restaurant or a warehouse, your employer pays 7.65% of your wages into Social Security and Medicare on top of what they pay you. They pay state unemployment insurance premiums so that if they let you go, you have somewhere to go. They carry workers' compensation coverage in case you're injured on the clock. As a contractor, you pay both halves of Social Security yourself. That's 15.3% of every dollar you earn. Taken before you buy a single gallon of gas. The platform contributes nothing to unemployment insurance, which means if they deactivate your account tonight, you cannot file a claim. No hearing, no appeal, no severance, no paperwork required from them. The expenses are also yours alone. Gas, oil changes, tires, the commercial depreciation on your car. If you're rear-ended on a delivery, workers' comp won't cover your recovery. If you get sick for a month, there's no paid leave. There's just a hole in your earnings. Here's the number that ties it together. A gig worker who sees $11 an hour on the app might feel like they're keeping pace. But once self-employment tax, fuel, vehicle wear, and the dollar value of the benefits they're absorbing personally are factored in, Human Rights Watch calculated the effective hourly rate at $5.12. That's less than half of what the app displays, and it's less than half of the federal minimum wage. Legally earned, legally paid, no violation occurred. By 2019, one state had seen enough. California passed AB5, a law built around a strict three-part test. To classify a worker as a contractor, a company had to prove the worker was free from the company's control, performed work outside the company's core business, and had an independently established trade or operation. Uber and Lyft failed all three. Under California law, their drivers were employees. Uber and Lyft challenged AB5 in court. They lost. So they did something no company had done at that scale before. They didn't appeal again. They bought a ballot. Uber, Lyft, and DoorDash spent $200 million on Proposition 22, asking California voters to exempt app-based companies from the employee classification law entirely. It was the most expensive ballot initiative in California history. 58% of voters said yes. The night Prop 22 passed, Uber and Lyft gained $13 billion in combined market value. Uber shares rose 18%, Lyft shares rose 22%. Prop 22 was also written with an 87.5% legislative supermajority required to amend it. Not a simple majority, not two-thirds, 87.5%. A threshold designed to be functionally unreachable. The California Supreme Court upheld it unanimously in 2024. On the federal level, the same arc played out. In January 2024, the Biden Department of Labor issued a rule that would have applied a stricter six-factor test to contractor classifications nationwide. It was scheduled to take effect in March 2024. The Trump DOL announced it would stop enforcing the rule on May 1, 2025. In February 2026, the DOL proposed replacing it entirely with a more employer-favorable standard. The protection that was supposed to arrive in 2024 was dismantled before most workers knew it existed. If this is the kind of story you want more of, subscribe. New videos every week. The ledger stays open. Here's what this means if you're one of the 27.7 million Americans now working as an independent contractor, a number that more than doubled between 2020 and 2024. Say you drive for DoorDash 3 evenings a week to cover your car payment, 15 hours. The app shows $11 an hour. Before you do anything with that money, 15.3% comes out for self-employment tax. Your share and the platform's share combined. Then gas, then the miles stacking up on your car. By the time the real math is done, you may be clearing less than $6 an hour. And if DoorDash deactivates your account on a Thursday night, no warning, no explanation, you cannot file for unemployment. You don't have a job to lose. You're a business owner. Your business just lost its only client. That is not a layoff. That is a market condition. Now here's what this means even if you've never opened a gig app. In 2024, 36% of the American workforce worked in some form of independent arrangement. That number has climbed every year. And the federal rule that would have slowed that reclassification just got replaced with one that makes it easier. The question isn't only what this costs gig workers. The question is which full-time job gets reclassified next. Because the legal structure is settled, the playbook exists, and the precedent that $200 million can buy a ballot measure written to be nearly impossible to undo has already been set. Here's what the ledger says. The contractor classification wasn't invented by Silicon Valley. It was a narrow legal category, written in 1917 for people who genuinely ran their own businesses. For decades, it sat in the labor code like a loaded mechanism that most companies didn't bother to pick up. Then a company picked it up, built a global platform inside it, spent $200 million to protect it when a state tried to close it, and watched the federal government walk back the one rule that might have tested it. This was never about flexibility. The platforms were never selling you freedom. They were selling you a word, contractor, that sounded like independence and functioned like a wall between you and the minimum wage, between you and unemployment insurance, between you and an employer who under any other classification would be legally required to owe you something. Your job didn't change, your classification did, and that one word is costing millions of Americans more than they know.